Welcome back to CJL 2000, Law and Legal Process. I'm Shane Nelson, your professor for the semester, and in today's lecture we're going to be going over our discussion of constitutional rights and liberty. Particularly, we're going to be looking at two major Supreme Court cases, Miller v. Alabama and Washington v. Glucksberg. With these two cases, although they involve just different factual situations, they are both fundamentally asking the same constitutional question. That question being, how far does individual liberty extend under the Constitution, and when may the government limit that liberty? And one of the major themes that we're going to continue to see throughout the course is that constitutional rights are rarely absolute. Courts are constantly balancing individual freedom against governmental interests such as public safety, order, morality, and different punishments. And Schubert emphasizes in his discussion of constitutional law that many of the constitutional disputes ultimately involve just competing interpretations of liberty itself. So what does liberty actually mean? Who gets to define it in our society? And we should also be thinking about how the courts determine whether a claimed right deserves any sort of constitutional protection. So all of these questions are the different things that we're going to be wrestling with today. But before we jump into the cases, I want to provide you guys with just a brief roadmap. So first, we're going to be discussing constitutional liberty and due process, and then we'll be moving into Miller v. Alabama, which just deals with juvenile sentencing. This falls under the Eighth Amendment protection against cruel and unusual punishment. And then after Miller v. Alabama, we'll be moving into Washington v. Glucksberg, which raises questions about physician-assisted suicide and due process. So moral and ethical quandaries all around here. We're going to compare these two cases, look at how the Supreme Court made their judgments, and how, the Supreme Court can sometimes come up with different constitutional protections while limiting them in others. And as we move through these two cases today, I would like all of you to think critically about this question. Should constitutional rights evolve alongside society, or should the court remain closely tied to historical traditions and original understandings? Again, there is no right or wrong answer here. I think this is something important that you should mull over as we move throughout the semester. So to begin, we need to define just what are our constitutional rights. Well, constitutional rights are protections that limit governmental power. That's extremely important to understand. Now, the Constitution generally does not regulate private behavior directly. Instead, it's more so just primarily limiting what government actors may and may not do. So, for example, the government can't censor speech in violation of the First Amendment. As much as some people would like to, if somebody says something mean from the FCC, you wouldn't go to ABC Corporation and try to have them fired, for instance, okay? So, again, First Amendment speech protected. The government cannot censor free speech in America. Additionally, the government can also not conduct unreasonable searches under the Fourth Amendment. You have a Fourth Amendment right against unreasonable search or seizure. And the government cannot deprive individuals of liberty without the due process of the law. Now, something important that Schubert discusses is that constitutional rights are not self-executing. The courts actually have to interpret these rights, and judges will determine how constitutional language applies to modern situations that the framers of the Constitution could have never anticipated. And like I mentioned before, because society is forever evolving over time, constitutional interpretation will also evolve. And that's one of the reasons why constitutional law can become politically and socially controversial. Now, this slide in particular introduces one of the more important constitutional concepts that we're going to discuss throughout the entire course, that being due process. Now, the Due Process Clause appears in both the 5th and 14th Amendments, and it states that the government cannot deprive individuals of life, liberty, or property without due process of the law. Now, there are two major forms of due process: procedural due process and substantive due process. Procedural due process focuses on fairness in procedures, such as like your hearings, trials, legal representation, and so forth. And substantive due process is different here. This doctrine asks whether certain rights are fundamental so that the government may not infringe upon them, regardless of procedure. And when we look at substantive due process, this is where the waters become a little bit more muddied, and we actually have to ask whether or not the constitutional law becomes especially complicated or controversial, and we have to really look at how should the courts decide which rights are fundamental to us. And are the judges actually discovering these constitutional rights, or are they creating them in real time? And so these questions are central to the case of Washington v. Glucksberg and Miller v. Alabama. So let's begin with Miller v. Alabama. Now, this case involved a 14-year-old defendant named Evan Miller. Evan Miller participated in a robbery and assault, which ultimately resulted in the death of another individual through arson. So, under Alabama law at the time, Miller was sentenced to receive life imprisonment without the possibility of parole. So, if we stop and think about this for a second here, this is sentencing a 14-year-old child to spend the rest of their life in prison with absolutely no possibility of release. So the constitutional challenge with this case centered on the Eighth Amendment, which prohibits cruel and unusual punishment. And so the question before the court, or the issue if you were writing a case brief, the question here became, can the government impose mandatory life without parole sentences on juveniles without considering their age, maturity, or potential for rehabilitation? So this was the core constitutional question in Miller. Does mandatory life without parole for juveniles violate the Eighth Amendment? So notice the wording here carefully. The court isn't saying that juveniles can't receive a severe punishment. The issue here is specifically whether mandatory sentencing schemes that ignore youth entirely are constitutional. And this reflects a broader constitutional tension. Should punishment focus purely on the crime that's being committed, or should the court actually have to consider the characteristics of the offender, such as their youth? Naturally, this question becomes especially important when dealing with juveniles. The Supreme Court ruled yes. The court held that mandatory life without parole for juveniles violates the Eighth Amendment. And this is because children are constitutionally different from adults for sentencing purposes. We have juvenile courts for a reason. Now, once again, this is not saying that juveniles cannot receive harsh punishments. This isn't even saying that juveniles cannot receive life without parole. What this is saying is that the court sentencing must be individualized, and judges should consider the age, maturity, family environment, peer pressure, and the possibility for rehabilitation when looking at the defendants. So this decision reflects the court's growing recognition that juvenile offenders possess reduced culpability compared to adults. And notice something important here. The court is interpreting the Constitution dynamically. It's not simply looking at the Eighth Amendment century practices. Instead, it's considering modern understandings of psychology, neuroscience, and child development. And I think that's important to note. So this leaves us with the question of why did the court rule this way? And when we look at this case, it's pretty evident that the court's reasoning is more so focusing on just the developmental differences that are pretty commonplace when analyzing juveniles compared to adults. So the majority opinion here is just emphasizing that juveniles lack full maturity, they don't have a frontal lobe development yet, they're more vulnerable to things like peer pressure, for instance. Juveniles, we all know this, we can act impulsively, teenagers, etc. Of course, juveniles possess a greater capacity for change and rehabilitation once they grow up and mature. And one phrase that you'll frequently hear in Eighth Amendment cases is the evolving standards of decency. So, like I mentioned before, with evolving standards in society, this is more so suggesting that constitutional interpretation should evolve alongside society's changing moral standards. And this creates an important debate. Should constitutional protections evolve over time, or should the Constitution remain fixed? And there were some critics that were unhappy with the decision in Miller, and you'll often hear them arguing that the courts are engaging in some sort of judicial activism by expanding the constitutional protections beyond what the text would state itself. And this leads us into more of the criticisms and debate that surround this case. So I think it goes without saying that Miller generated significant debate. Many supporters argue that the decision made here recognized scientific realities about juvenile development and created fair sentencing practices for juveniles. But many of the critics, however, raised concerns about just victims' rights, the public's safety, and judicial overreach. Many of the critics actually argued that certain crimes were so severe that age should not substantially reduce punishment, and others believed that the courts, not the legislators, were making major policy decisions about criminal punishment. So you can see here there's an obvious tension building between judicial interpretation of text and democratic policymaking. And this is something that we're going to continue to return to throughout the semester. But I would urge you to think about this. Should constitutional protections expand even when doing so limits punishment for extremely serious crimes? So now we move into the case of Washington v. Glucksberg, which deals with a very different constitutional issue from that seen in Miller. Washington state had laws in place that prohibited physician-assisted suicide. Several physicians came forward and challenged the law, arguing that terminally ill patients possess a constitutional liberty interest in choosing the timing and manner of their own death. So in other words, these physicians are essentially arguing the Due Process Clause protected a right to physician-assisted suicide. And this case raises major ethical and constitutional questions, obviously. So one of these questions being, does liberty include the right to die? Do you have a matter or a say in your own death? And should individuals possess autonomy over the end of their life decisions? And finally, does the state have a legitimate interest in preserving life? So we move into the constitutional question, which in my opinion is pretty straightforward, but still enormously controversial. That question being, does the Constitution protect a right to physician-assisted suicide? Now, notice how this is quite different from the case of Miller. In Miller, the court expanded constitutional protections of juveniles, but here the court had to determine whether or not a completely new liberty interest should receive constitutional protection under a substantive due process. Now, ultimately, the Supreme Court unanimously ruled no. The court held that the Constitution does not protect a fundamental right to physician-assisted suicide. Chief Justice Rehnquist emphasized that asserted liberty interests under substantive due process must be deeply rooted within the nation's history and tradition. So therefore, the court concluded that the states could constitutionally prohibit the practice of assisted suicide. And this is a much more restrained approach to constitutional interpretation compared to what we had witnessed in the case of Miller. Now, the court offered several different explanations for how they came to this decision. First, they stated that the government possesses a legitimate an interest in preserving human life. Second, the court worried about potential abuse and coercion involving vulnerable patients, perhaps people who were mentally ill or not able to come to these decisions on their own. Third, the court emphasized medical ethics in the traditional role of physicians. Think of the Hippocratic Oath, for instance. And finally, the court stressed historical tradition. So unlike rights such as marriage or, say, parental authority, physician-assisted suicide lacks deep historical roots, and therefore it doesn't have that much of a constitutional protection. So when we look at Washington v. Glucksberg, I would say that this case demonstrates how difficult substantive law can become. And you should ask yourself, how should the courts identify fundamental rights that are not explicitly written into the Constitution? Because this question remains one of the more controversial issues in constitutional law today. So once again, these two cases create quite the interesting contrast when you compare them to one another. In Miller, the court expanded constitutional protections by emphasizing the evolving standards, how we view both juveniles when comparing them to adults, and the possibility that juveniles have for rehabilitation later in life. And when we look at Glucksberg, the court is really just rejecting this overall expansion and emphasizing that historical tradition and judicial restraint should come first. So notice here that the Supreme Court does not always move in one ideological direction. Sometimes you'll have rights expanding, and sometimes the courts will defer to almost originalism with the legislators. So ultimately, constitutional interpretation really just depends on the justices' judicial philosophy, what historical analysis we have available to us, the evolution of societal values, and of course the competing understanding of just what liberty is. So to wrap up today's lecture, there are several important concepts that I want you guys to remember before we move forward. First would be constitutional liberty is constantly contested and debated. Second, due process plays a central role in defining the limits of governmental power. Third, the Supreme Court possesses an enormous amount of influence in shaping our constitutional rights. You've seen this throughout history, and you will continue to see it throughout history. And lastly, constitutional interpretation involves difficult questions about morality, history, punishment, autonomy, and judicial power. All of these are paramount importance, and as we move forward in future lectures, we're going to continue to explore just how these constitutional protections apply in areas involving criminal procedure, voting rights, incorporation doctrine, and individual liberties.